Hello, my name's Laura Clapton. I'm a family mediator and a family solicitor at Concilia Legal. Today I'm joined by two leading children arbitrators, Julia Nelson, who is a barrister at Partley and Plowden, and Jane Ingleby, who's the head of the family law team at Mills and Reeve in Leeds. Thank you both for joining me today. So today we intend to demystify how child arbitration works, when it might be the right option, and how it dovetails alongside mediation. So Julia, I'm going to turn to you first, if that's okay. Can you explain to us what type of situations are appropriate for child arbitration?
Thank you, Laura. Yes, certainly. It's pretty much any private law issue that could otherwise be decided by a court about a child's upbringing. So, where they live, the time that they spend with each parent, what school they go to, holiday arrangements, even a domestic relocation inside England and Wales, all of that really falls squarely within the IFLA Children's Scheme.
Okay, and turning to you now, Jane, are there some circumstances that are just not appropriate for child arbitration?
Yes, that's right. So if there's an international child abduction application under the Hague Convention or a proposed move to a non-Hague country, life-changing medical treatment, or when someone lacks mental capacity, then the rules say that these must stay within the court process. Safeguarding flags can also stop an arbitration, but not always. So that will depend on the circumstances of what the safeguarding concerns are.
Okay, thank you. And so, Julia, can you give us a flavour for or an example of a case that you have determined as a child arbitrator?
Certainly, Laura. I recently determined a dispute about whether two siblings who were 10 and 8 should move schools. The mum had relocated 45 minutes away from the children's school, and both sides really needed an answer. So after a one-day hybrid hearing that was organised at short notice, I, within 2 weeks, produced a written determination so the children know exactly where they'll start the September term. The parents know where they stand, all months faster than could possibly achieve by a court application.
Absolutely. And so many of our viewers will be mediators and may be wondering, Jane, how do the two processes of mediation and arbitration complement each other?
Well, they do massively complement each other. Since last year, the family procedure rules now actively encourage non-court dispute resolution. And this is actively encouraged by the court. And there is an expectation that serious consideration is given to NCDR. So the two processes work really well together, as a mediator can carry on working on the areas of agreement while parking any sticking points with an arbitrator for a binding decision. So they do work alongside each other and dovetail together.
Brilliant. And so, Julia, how do parents refer themselves to arbitration?
So what they do, Laura, is they sign a form. It's an ARB1CS, and they also fill out a short safeguarding questionnaire. And then they choose an arbitrator. And they can do this either by recommendation from a solicitor or a mediator, usually, or they can choose somebody who's on the IFLA children panel. Or if they don't agree, then they can ask IFLA to nominate a suitably qualified children law arbitrator. And then they send the forms to IFLA. And once the arbitrator is accepted, then a first directions meeting is usually arranged within days. So they can have that usually done online, an informal meeting to begin with, where the directions are sorted out.
Okay. And so if, let's say, for example, each parent has found an arbitrator that they would like to use, or perhaps their solicitor has recommended a particular arbitrator, is it possible to ask IFLA to decide on the arbitrator from a sort of shortlist?
Yes, absolutely, and that's quite commonly done. Or you could decide that one party nominates 2 or 3 arbitrators and the other one picks one from those 3. So then both parties have had a hand in deciding who's the best person.
Okay, that makes sense. And so, Jane, as a mediator, I often have circumstances within a mediation where the parents are able to reach a partial agreement and partially mutual proposals. But there are just some sticking points, and that could be logistics, for example, and but they just can't seem to decide on those and agree upon those points. How does that then work alongside arbitration, where there's a partial deal in mediation?
So it can flow quite naturally between mediation and arbitration. So you could then refer the sticking points, if you like, or the blocking issue to an arbitrator. The mediation is paused while the arbitrator makes a binding decision on that particular issue, and then it can flow back to mediation for the rest of the issues to be determined. So it does work very well together, and it can flow between the two.
Okay, brilliant. So it's not just a case that arbitration is a process that determines the final outcome. It can very much deal with those, as you say, those sticking points and those preliminary issues, and then the parties can then continue through mediation, having had that issue determined.
That's actually, the advantage of it. And it may be that the arbitrator's involved right at the beginning. There may be one single blocking issue that's stopping the mediation being successful. That can be determined by the arbitrator, and then the parties can go back into mediation.
Okay, so Julie, would you say that the arbitration, it's a fairly flexible process?
It's absolutely, it's probably more flexible than anything else, because you could start mediation, find that you had a block, get an arbitrator to decide on that, or you could have gone to court and neither party is happy with the amount of detail that there is, and there are still issues to be tried, and an arbitrator could do that on paper, or by having an arbitration hearing. It can be hybrid. So it is really immensely flexible. But you also know that you have got a trained children law specialist and a member of the Chartered Institute of Arbitrators. And I'm afraid that's not something that you can guarantee in the court system, that you've got somebody who has got a lot of experience in children law.
Thank you. And so, Jane, some of our viewers might be thinking, well, why not just stick with one process? You're either arbitrating or you're mediating. What would you say to those queries?
We touched on that, haven't we, in that they complement each other. So mediation is so effective for parents who want that autonomy of reaching an agreement themselves for their children, but may find that they can't actually reach an agreement on all the issues. And then you have the advantage of an arbitrator being able to listen to what the concerns are, look at the evidence, and make a decision based on what's in the best interest of the children. That is still obviously the priority. And then it can move back to the mediator to either help with the implementation of the arbitrator's decision, or to resolve any of the other issues that may be outstanding that the parents feel they can reach an agreement with the assistance of the mediator.
Thank you. And Julie, you've already touched on this, that in terms of arbitration it is flexible and there are different formats. So does it always involve some sort of hearing?
No, it doesn't have to involve a hearing. It can be done on paper or on the papers. Commonly, if there's an issue to be tried, the solicitors might agree that they will put their client's position in a position statement, maybe with a draft order. I'll have a neutral case summary of the background. I'll be able to see what each party is saying and the reasons why. And I'm always very happy, and I know Jane is too, to determine a case such as that on the papers. And I'll give a written determination within 2 weeks.
Okay, super, thank you. And then what about expert evidence? So as we know as lawyers, expert evidence can come into it. And so, Jane, as an arbitrator, are you able to order and deal with issues concerning expert evidence?
Yes, we are. So CAFCAS isn't available in arbitration, but we are able to appoint an independent social worker, and also we can look at child inclusive mediation reports. They can be very effective in helping us achieve a decision. So yes, we have those powers that's similar to the courts.
Okay, thank you. And Julia, our viewers might be wondering, what happens if the parents decide to go down the arbitration route, but then one of them has second thoughts?
Well, entering into arbitration can only be done by consent, and that involves both parties signing the ARB C1S. But once they do, then they're contractually bound to see it through in arbitration, unless there's some safeguarding concerns that emerge. So in the same way that you're bound by a court's decision, unless it's something that's outside of the reasonable ambit of discretion of a judge and therefore appealable, it's exactly the same in arbitration. Once you've signed up to it, you have to agree to be bound by that decision. It'll be subsequently registered as a court order, and unless there's something again that's appealable, you're bound by that decision. So once you enter into it, it's a contract and you are just as bound by it as you are in a court.
Okay, thank you. And so just thinking about it as a mediator, if the parents have signed up, so they've signed up to arbitration, and they've decided to possibly delay any determination to allow them to engage in mediation, but unfortunately mediation doesn't lead to a successful outcome, they are then, because they've signed the ARB1 and they're in arbitration, they will then be bound by then the determination of the arbitrator following an unsuccessful mediation.
If it's that same issue, so if another issue came up in mediation, one that they hadn't decided to arbitrate, and therefore that wasn't the issue that was set out on the ARB1 CS, then they wouldn't be bound by it in those circumstances. They would have a choice to either not decide the issue, or to go to court and have a court decide the issue, or to have it dealt with by an arbitrator. But the difference, I think, is this, that if a mediation has broken down or is breaking down because of a single issue, if you agree to go to arbitration, you can do it quickly and you can get a decision. Whereas if you go off mediation to get a court appointment, there could be many, many months, and you've no guarantee that you won't be put before magistrates who don't have any legal qualifications and are not children law specialists, or a non-specialist judge. Whereas if you've chosen the judge, you know that you've got somebody who's a children law specialist who'll do it in a timely and quick manner, and it will usually end up saving a lot of money in the long run.
Thank you. I can see Jane nodding there. Thank you. Thank you, Julia and Jane, for such clear insights. Now, if anybody wants to find out more information about child arbitration, you can visit the Family Law Arbitrators website, or you can contact us at Northern Resolve, and we'll be happy to answer any questions. So thank you, ladies. Thank you for your time.
Thank you, Laura.
Thank you. Thank you.
Thank you. Goodbye.
Bye.